All right, thank you. Date and time of the adjourned preliminary examination. Are parties ready to proceed?
We're ready, Your Honor.
Yes, Your Honor, defense is ready.
All right, you may proceed.
People call Ember Grady.
And please come forward, be sworn.
Raise your right hand. You solemnly swear to put your testimony about what the Lord is the truth, the whole truth, and the truth. Name, spelling, name, career.
Grady, EMDERGRADY.
Thank you. You may inquire.
Thank you.
Your Honor, I apologize. I forgot to make a sequestration motion.
And I would have an objection to that.
Okay, yeah, any witnesses that are going to testify hereby ordered sequestered from the courtroom and not to discuss any testimony that they may be giving.
May I request an exception from my officer in charge?
The officer in charge may remain in the courtroom.
Thank you.
Thank you.
All right, go ahead.
Good morning, ma'am. How are you doing? Doing just fine. Thank you for asking. Ma'am, how are you employed?
Senior paramedic at Huron Valley.
How long have you worked for Huron Valley?
Since July 2019.
Were you working in the same capacity on or about May 25th of 2025?
Yes, sir.
And were you specifically on shift that day? What shift were you working?
Regular.
What shift is that?
Fine. Was 7:30 p.m. 7:30 a.m.
So you were on shift 7:30 p.m. the night before the 24th, is that correct?
Yeah.
All right.
That should be fair.
No problem. Specifically in the early morning hours of May 25th, 2025, were you ever on I-94 Adderton West 12? Why were you there?
First, he wants to goes to another call in Belleville. We needed to take it for it.
When you say we, who's we?
My partner,
What's your partner's name?
Alex Shankowski.
While you were en route to that call, did anything happen that caused you to stop on I-94?
I guess we spotted a man who was new on the shoulder of the highway.
Do you remember which way or which direction of traffic on the highway you were? Eastbound or westbound, I guess.
Going eastbound.
And you said that this individual was on the shoulder. Which shoulder?
The right one, it's like the slow lanes.
What did you do when you saw this individual?
He stopped the ambulance, my partner was driving. I radioed into dispatch to let them know what we had spotted and that we wouldn't be stopping. So that they could send someone else to the call that we were already hitting on. And then. So yeah, I had radioed that, we were stopping. We asked for police to come to our scene. And my partner started to put the emergency lights on, and started to reverse the ambulance to try to get closer to the individual.
You said that you stopped the ambulance. Where did you stop the ambulance?
In the right lane.
In the lane or off the road?
In the lane.
Okay.
It's the lane we were traveling in.
The slow lane,
Yes.
the right lane. Okay.
What happened after you started to reverse the vehicle?
He shot the individual. It started to kind of run towards us. And it looked like he had something in his hand, but neither one of us could see what it was. So we kind of started pulling forward a little bit and we locked the door just in case. Because we don't know this person. I radioed to dispatch again that he's charging at us. We would like police to come priority one, which is like sirens, like step it up. Because he could be a danger to himself, to others, we don't know.
At the time that you're seeing this individual, are you looking directly at him?
I was looking in the side mirror, so we have two mirrors basically. It's the larger mirror and then there's a smaller like toe mirror. I was looking between the small toe mirror and when my partner said like, oh, he's running towards us, I kind of like leaned forward and tried to see him in the larger mirror to see if I could see what he was holding, but I couldn't, and then I just went back to looking in the small mirror.
And you're the passenger, I think. Okay.
I don't think I clarified earlier. Do you remember what time specifically you saw this individual?
It's like 2 something.
AM or PM? Okay. What happened after you radioed for police assistance?
So we had pulled the vehicle forward a little bit, my partner did. And the individual on the road kind of stopped, like put his shoulders down, turned around and started walking back the way that he had originally been walking.
At that point, do you remember, was this individual on the road or on the shoulder? How far off the road was this individual at that time? What happened after he turned around and started walking away?
I had tried to radio dispatch again, to let them know that he was walking towards like a curve in the road. And to let the know so that they don't. I did not get to complete that transmission because it was the.
When you say the individual was hit by a car, do you know what type of car it was?
You can tell that it kind of like continued by my passenger door. I saw the headlights and general.
Can I just stop you there? Because I'm trying to get it. When you say continued past your door, that's the vehicle did?
Yes,
Okay, go ahead, Mr. Pickles, sir.
so I saw the headlights, the general outline, I saw that it was a 4-door sedan in dark in color. With like not the LED headlights, like the older headlights. And I saw that it was kind of going sideways, like the headlights were pointing to my door. And it struggled to regain control and then came to a stop ahead of us.
I want to make sure I'm understanding correctly. You said it passed by your door, and you said you're the passenger in this vehicle, right? When the vehicle passed you, was it on or off the roadway?
It was on the shoulder.
Okay. So it goes past you on the shoulder. Does it go back onto the roadway or does it stay off the road?
It went back onto the roadway, as the person was trying to take.
Okay. And while you were testifying, you sort of made a gesture with your hand. It's sort of like fishtailing. Is that what the vehicle was doing?
Yes.
Okay. Were you able to see who was driving that vehicle?
No.
At the time that this happened, were you able to see where on the vehicle, or let me rephrase this question. Were you able to see where the vehicle made contact with this individual?
So when I was looking at the small mirror and I saw the headlights kind of cross the individual turning towards the road, like towards my ambulance. And I saw the silhouette of the individual and then I heard the of contact. And after we got out of the ambulance to try to look for him, the driver, there was specific type of glass that was on the roadway that doesn't come from a windshield, it only comes from the side windows.
You said that you heard the thud. Did you hear any like tires squealing?
Yes, I did.
How long before or after the impact did you hear that noise?
I only heard the tires screeching right before the thud, and then I didn't hear them screaming.
I believe you said that you left and tried to find the individual that was hit. Did I hear you correctly?
Yes.
Were you able to find that individual?
This is the moment the entire case pivots from concern to catastrophe. What begins as paramedics trying to help a vulnerable man on the side of the interstate suddenly turns into a horrifying sequence of events. The witness described seeing headlights close in, hearing tires screech, and then witnessing the devastating impact itself. Within seconds, a routine response becomes a fatal scene, and the chilling details of what happened next immediately raise the central question that will dominate the rest of this courtroom battle. Could this tragedy have been prevented?
Yes.
Where did you find that individual?
And started our search where we did last season. And kind of scanned the area, we scanned, as wide an area as we could, really. Go anywhere. We found him, 100, maybe 150 feet up from where we last seen him. There's like a south wall on the highway, found him up against the south. Yeah.
Make sure I'm understanding correctly. You said about 100 to 150 feet. Is that off the side of the road or forward, backwards? What direction is that?
So it's forward and maybe 5-ish, 6-ish feet to the right towards the south wall.
And when you say forward, is that the direction of travel the car was going? Okay.
So. Okay. So the individual that struck is now ahead of the ambulance?
I believe he ended up maybe around where the ambulance was.
Gotcha. Okay, so, and excuse me, I'm just trying to get a layout in my head. Where on 94 are you?
So we are eastbound, just west of Rossonville exit.
Just west of Rossendale. Gotcha.
So I wish I had a map to show you.
No, I got it. So you're just west of Rossendale. Okay. And described the individual initially coming toward the ambulance, then going away from the ambulance. How, at the point of impact, how far estimating is he from the ambulance?
I wouldn't be able to give you a good estimate on that.
Okay, that's fine. And I got that. But and your ambulance is still in the right-hand lane of I-94.
Yes, we
Oh.
put it in park.
Got it. Okay. Last question I have for you at this point. When you are describing, just so the record's clear, when you're saying on the shoulder, tell me what you mean by shoulder, rather than try to put words in your mouth. I know what you mean.
The solid white line that has.
Got it. So, gotcha. So when you say shoulder, anything which would be to the right of that white line, you're describing as the shoulder. Thank you. Go ahead.
Thank you. What did you do when you found the individual who was struck?
My partner made first contact. Let's read more details on what. But I don't know, it was maybe like this deep, like a foot deep, and it was filled with water. He put a backboard over it, crossed it, got to the victim, and said, "I think I feel the pulse." So I determined that we needed to get him into the ambulance to do a further assessment on him and perform life-saving measures.
At any time that you're doing this, did any individual from the car that struck this person leave the vehicle and assist?
I did not see or hear any car doors opening or anyone get out of it.
How long did the car remain on scene?
I don't know how long. When we found him and I looked up, the car would come.
How long did you spend searching for the decedent?
Less than 30 seconds.
So sometime within then, that other car left. After you got this individual back into the ambulance and you were performing life-saving measures, what happened then?
I had radio to get a supervisor. The supervisor showed up and another unit from our same company that happened to be going that direction had also stopped to give us some help. They got in And I was doing chest compressions and he, the way that our protocols work, if it's what we call a traumatic arrest, so no pulse, no breathing due to a traumatic cause, we have to put them on the cardiac monitor, look at their heart rhythm, and then call a doctor based on that. So that it's what we.
Were you able to, or let me phrase the question this way. Was this individual pronounced dead at any point that night? Do you remember what time that was?
I would have to look at my report.
Were you able to identify who this individual was?
I believe when we did it, we got his name later from, it was either the coroner or police found out his name. I don't know.
Okay, that's fair. And just to be clear, when this crash occurred, was this in Washtenaw County?
Yes.
Other than yourself and the vehicle that struck the decedent, were there any other cars on the road at this time? Did you observe anything like a deer crossing the street or anything like that? What was the weather like?
Just a regular night.
I may have just one moment here.
And also, I just want to clarify something while you do that. At the time of impact, all of your lights on your ambulance are activated? Okay.
Ask the witness, Your Honor.
Okay, cross-examination.
So, Ms. Grady, you remember talking to the police on the night that this happened, right? I believe it was Trooper Ryan that interviewed you on the scene, right? Okay. Sure. So, one of the police officers interviewed you on the scene that night, right? And do you remember telling that officer that you witnessed a small black sedan hit the decedent? I'm sorry, just for the record, we need a yes. Okay. And you gave a lot of information today, details about distances and things you remember. Do you remember if you gave those details to the officer the night that this happened?
I don't believe I gave just details.
Okay. Do you remember going into specifics about what you saw in terms of the man on the side of the highway the night that this happened?
I saw him.
Do you remember telling the officer specifics about like where you saw him and what he was doing on this evening before the crash? Okay. But you don't remember giving the estimates as to the distance that he was located near the side of the highway, is that right? Okay. And I do want to clarify something as well. You said you located the decedent up against, you said a sound wall. Could you explain what that means?
The wall that's on most highways to prevent highway noises from going to neighborhoods.
Okay. And you remember you testified on direct that you were looking in the area, you were looking for the decedent, right? Do you remember seeing a variety of debris in that area as well? Do you remember seeing actually parts of cars in that area?
What ended up being like a mud flat from a semi that said Volvo on it. It was broken apart. It was in the shoulder.
Okay. And do you remember there was also a back panel of a car from Cadillac? Do you remember that? Okay. Do you remember there being a variety of debris in that area though? There's debris, there's garbage, right? Okay. Do you wear body worn cameras? Okay, and you don't have dash cams on your ambulance, on your vehicle, right? Okay, do you now? Okay. You also mentioned that there was sort of a ravine that was filled with water. You'd agree with me that that creates some uneven terrain on the shoulder, right? And you testified that your partner actually put I forget what you called it, but some sort of, you said backboard. Okay, and that's so that you could walk over it safely, right? And I want to ask you some more questions about the sort of what the highway, this specific location of the highway. So you testified that there was a curve in the road. You'd agree that there's, as far as I-94 goes, it's a pretty substantial curve at this location, right? And so you testified that you heard tire screeching before you heard a thud of an impact, right? Did you see the brake lights on the car or do you not remember?
The brake lights weren't facing me until it was in front of the ambulance. So no.
Okay. Could you see tail lights or rear lights, rear brake lights or not? Okay. How many seconds would you say you observed the individual who was the decedent on the side of the highway before the accident?
Don't know how many seconds. I would say it was easily at least 2 minutes.
Okay, 2 minutes.
Sometimes at least saw him stop, did go back and forth, but then he was.
Okay. So you saw him, did your partner stop the vehicle pretty instantly after you saw him?
As safe as possible.
Okay. So you saw him stop the vehicle and then he reversed the vehicle, is that right? And were you observing him in the rear view mirror for that duration of the time? The side mirror, okay. And you said at one point he was approaching your vehicle, so you locked the doors, right? And I'm sorry, just for the record, is that a yes? Okay. And you actually testified on direct that you thought he was maybe charging it at you, is that right? And you saw something in your hands. Now, would you describe that object as being larger than the side of a kind of standard hand that he was holding? Okay. Could you tell whether it was, what type of object it was?
Not at the time.
Okay.
Looking at what was left in the road in that area was kind of just figured it might be the mud flat, but we don't know for sure.
Okay. But you don't recall seeing many specifics as to the object that he was holding in his hand. Okay.
Something.
And to be clear, it wasn't really your job to look closely in the scene once you found him. Is that right?
To our best to get as much information that would lead to treating the patient. But not in like the police officer, law enforcement mentality.
Okay. Were you aware of any prior calls made regarding that individual before you stopped? Okay. When you talked with, was it you that talked with the dispatch? Okay. Did they mention that they received prior calls about this individual as well?
Found out later that they had, but I don't believe at the time that they did.
Okay. Do you recall how many calls they received about this individual that evening?
I'm not in dispatch office, I don't know.
Okay. So do you recall how long it took police to arrive on the scene once you made that request?
wouldn't feel to tell you a specific time, but
Okay,
say anecdotally, it was very.
okay. So you mentioned you had a supervisor come to the scene. Is that standard protocol or what led to that decision?
Things hitting the door and left side of the ambulance. I thought that something hit our vehicle, it turns out it was just ground and stuff with the shoulder. There wasn't any actual damage.
Okay. At one point, did you think that the vehicle that had hit the decedent also hit your ambulance?
I didn't think that the vehicle itself did. I thought that maybe something had come off the vehicle and hit our ambulance.
Okay. Is it fair to say that in the moment that you were talking to the police the night this happened, there was a lot going on, right? And your primary focus was tending to the patient, right? And you were saying information about what you thought you remembered in that moment while you were tending to the patient, right? So you didn't know if something had hit your vehicle, right?
Once he was pronounced dead, I went and looked at our ambulance to see if there was any damage.
Okay. Mhm. You testified in direct examination that there weren't any other cars on the road at this time. Wasn't it the case that you radioed for another ambulance to go to the location you were initially headed towards?
That is not our job to do. That's the dispatcher's job.
Okay. Just to be clear, you did see other vehicles driving on I-94 that evening, right? You did see other vehicles driving in that location while you were talking to police, right?
When you're talking to police, they had already shut the highway down.
Okay, so they shut the highway down. Before they shut the highway down, there were other vehicles traveling on I-94, right?
And it's my ambulance performing that.
Okay. So before the accident, you had seen other vehicles traveling on I-94 that evening, though, right? During your shift. And that was around 2:30 in the morning, right? Now, I want to talk to you about some more about the investigation in this case. So you talked with the police the night of. Did you ever have any follow-up interviews with any police officers?
Yeah, exactly.
Yes.
So the last court date that we got.
Okay. And then who did you speak with the last court date?
Prosecutor. Just the prosecutor.
Okay. So did the police officer do a subsequent interview with you at all at the last court date? Okay. So it was just that evening, as far as you can remember, that you gave your statement to police, right? And just to be clear, you couldn't see, it was obviously very dark outside, right? And the vehicle that struck the decedent, you couldn't see inside that vehicle, right? You don't know how many people were inside that vehicle, right? You don't know the race of the person driving, right? You don't know if it was a man or a woman. You have no idea who that was, right? Okay. I have no further questions at this time.
You redirect.
No, Your Honor.
Ma'am, I just want to make sure you're indicating that the point of impact was west of Rossendale Road or west of West? Okay. West of Rossendale Road. So the entrance exit to Rawsonville, you're on the western side of that. Yes, okay, thank you. Anything else based upon the court?
No, Your Honor.
All right, thank you. You may step down. May call your next witness.
People call Sergeant Ryan Bowden. Apologize, I believe he may have just stepped into the restroom.
All right, that's fine.
There it is.
Sir, please come forward, be sworn.
Please right in. Do you solemnly swear affirm the testimony about to give us the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, spell your name for person.
Name is Ryan Bowden, RyanBoden.
Sir.
You may inquire.
Thank you. Good morning, Sergeant. How are you doing?
Or sir,
Sir, how are you employed?
currently as a sergeant, Michigan State Police,
How long have you worked for Michigan State Police?
10 years.
In what capacity over that 10 years?
Trooper up to September of 2025.
And is that when you got promoted to sergeant?
Yes,
Were you working for Michigan State Police on or about June 6th of 2025?
yes.
And on that day, were you ever asked to assist with investigations related to a crash that occurred earlier in May of that year?
Yes, that was.
How were you assisting with that investigation?
I was asked to speak to an individual who advised he has information about that incident. And then later on to inspect the vehicle and attempt to interview someone possibly.
At any point on June 6th of 2025, did you have a conversation with an individual by the name of Corey Folk?
Yes.
Do you see that individual in the courtroom today?
Yes.
Can you please point to them and identify them by an article of clothing that they're wearing?
Sitting to my left, wearing a blue suit and a red tie.
The record may reflect the witness has identified the defendant.
Without objection, the record shall so reflect.
Why did you speak with the defendant on that day?
The initial conversation that I had that morning, that person identified Mr.
Objection.
What's your objection?
Well, hearsay, and also relevance, we already have to
The
find.
statement is going to go to his state of mind as to what he did. So it's not hearsay. Objection's overruled. Go ahead, Mr. Cook.
I didn't know why I had Mr. as someone who may have been involved. And so I was attempting to interview him as to damage.
And when you say attempting to interview him, who is him? Were you able to interview the defendant? Where did that interview take place?
At the State Police Jackson Post.
At the time you interviewed the defendant, had you taken him into custody?
No.
How did the defendant arrive at the Michigan State Police Post?
Transported him there.
Did he agree to get transported there? At any point, let me rephrase this. Did you advise him whether he was free to leave at any point?
I did.
Was he free to leave at any point? Yes. Did the defendant agree to speak with you on that day?
Yes.
I want to sort of go the day before May 25th to May 24th. Did the defendant say when he woke up that morning?
Yes.
When did the defendant say he woke up on the 24th? Over the course of the day of the 24th, where did the defendant say that he was that afternoon?
We say he worked and then attended a Detroit Tigers game.
When the defendant was at the Detroit Tigers game, did he say whether or not he had anything to drink? What did he say? What did the defendant say he drank?
Initially advised he had a couple of beers, and I believe later clarified
At the time of that,
Sorry, what was that last word?
3.
3. Okay.
Yes.
at the time of the Tigers game, do you know how old the defendant was?
under 21, but I do not know exactly.
Did he say if he was with anyone else that afternoon?
Yes, he did.
Who was he with?
A friend of his named Adrian Putnam.
Defendant says he's at a Detroit Tigers game. How long did he say he was at that Tigers game?
He stated he arrived to the Detroit area 6:30 and stayed until approximately 11
Where did the defendant say that he went after the Tigers game?
p.m.
Did he say what he was doing in Ann Arbor?
Was at Pinball Pete's.
How long was the defendant in the Ann Arbor area?
He stayed until approximately 2 to 2:15 a.m. the following.
Of the 25th? All right. Where did the defendant go after, or where did the defendant say he went after he left Pinball Pete's?
He said he went to take towards Elm Park to take his friend home.
Did he say what route he was taking to get there?
He did not know the exact roadways, but he stated it was the freeway and he was traveling towards Elm Park, so east.
While the defendant was driving towards Allen Park, did he say how fast he was going on the freeway?
He approximated his speed around 90 miles an hour.
While on the freeway, did he say whether or not he was distracted by anything?
Yes, some flashing lights.
What about the flashing lights, or what statement did the defendant make regarding these flashing lights?
He advised he saw some flashing lights as he was on the freeway and he believed that they were on the other side of the freeway, so the westbound side. And that's when he saw that.
Did the defendant say how hard he hit his brakes? Did the defendant say whether or not he was able to maintain control of his vehicle?
Was not able to maintain control of his vehicle.
Did the defendant say whether he was involved in a crash at that time?
Yes, he stated he collided with something.
What did the defendant say he did after he collided with something?
Looked around, asked his friend if he was okay. Sat there for 2 or 3 minutes and then left.
Did he ever tell you that he got out of the car and rendered aid or assistance to anyone?
He said he did not get out of the car.
Did he ever say if he reported this crash to police?
Said he did not report it.
Did he give a reason why he didn't report this to police?
This testimony delivers one of the most damaging pieces of evidence presented in the hearing. According to investigators, the defendant admitted he was traveling around 90 miles per hour when he noticed emergency lights ahead. He then braked, lost control, and collided with something on the roadway before ultimately leaving the scene. In just a few moments of testimony, the courtroom hears details that transform the case from a simple crash investigation into a serious examination of judgment, responsibility, and the decisions made after impact.
He was afraid of this show.
Did he say where he worked? I'm sorry.
Yes, it was in Jackson. I can't recall the name of the company, but he was afraid a driving charge would cause him to lose that job.
A drunk driving charge. Thank you. Go ahead.
Other than drinking, did the defendant say he used any other sort of intoxicating substance?
I asked him and he stated
And did the defendant say what vehicle he was driving?
his vehicle is Chevy Malibu.
What sort of vehicle is it? An SUV, a truck, a sedan?
Mhm.
Did the defendant say whether he was using his phone at the time of the crash?
He said he may have done.
Did you ever personally see the defendant's vehicle?
Yes,
When you observed the vehicle, was there any damage on it?
yes.
What sort of damage was on the vehicle?
Dent, I guess, best described as a dent on the rear quarter panel,
Which side?
right side.
So passenger side? Okay. What about the windows? Were the windows damaged in any way?
There was a,
Which window was broken?
I do not recall.
If I can have just one moment, please, Your Honor.
Yes, ma'am.
Ask the witness.
Cross-examination.
So Sergeant, you testified on direct that he said he did not report this to police. You actually got his name from Trooper Davis, isn't that right?
Mr. Davis is not a trooper.
Mr. Davis is employed at the police, isn't he?
I believe he may be your corrections.
Brief moment, Your Honor.
Yes.
So you're aware that Mr. Davis is employed in some capacity with police? Or you don't know?
Like I said, I believe these corrections, which.
Okay.
Entity that would belong.
Do you say you believe? Do you remember or do you not remember how he's employed?
I believe he's a corrections officer.
Okay. So do you recall, was it you who followed up on the conversation with Mr. Davis, or was it not you?
Yes, I did follow up.
Do you recall referring to him as Officer Davis?
I may have.
Okay. And do you recall which agency you called to follow up on this information?
No.
Okay. But, okay. So do you recall that you actually called a police agency regarding a call that Mr. Folk made about this?
It was his supervisor.
Okay.
Is
Mr. Davis
Davis the supervisor?
is the one who contacted our post regarding this entire instance.
Got it.
Okay. And was it a part of your responsibility to investigate anything that Mr. Folk told you?
I was assisting at that time. I was not the officer in charge of the investigation. So I was merely asked to interview Mr. Folk and check on the vehicle.
Okay. So did you ever go view the surveillance cameras at Pinball Pete's to verify what time he may have left or what time he was there?
No, I didn't.
Okay. Did you ever ask any of the other officers to do that?
No.
Okay. That wasn't your part of your responsibility in the investigation? Okay. Did you ever view or request to view any surveillance from Detroit, from the Tigers game regarding, okay. You're aware that you had information that the damage to Mr. Folk's car was actually caused in Detroit at the Tigers game, right?
That's what he initially told me and then changed that statement later on.
He told you his rear window damage was from a break-in in Detroit, right?
That was his official statement. That's correct.
You're saying that that part of the story, that the window damage, specifically the back panel, I'm not talking about the siding of the car, but the back window, you're saying he changed his story about that damage?
Changed his damage to this.
He told you that he had a witness who would verify that his car was actually broken into in Detroit, right?
Yeah, I was part of this interesting.
Your Honor, permission, well, brief moment, Your Honor. Um, Sergeant Ryan, or Sergeant Bowden, excuse me, you would recognize a copy of the written report you made about this, right? Permission to approach the witness?
Okay.
May I approach physically?
Right.
Okay. Can you point out where in the written summary of your interview with Mr. Folk, you indicated that he changed his story about specifically the back window?
To object to that.
Well,
Also hearsay.
yes, but I note those, but I'm trying to figure out where, when you say back window panel, what are you referring to in your question?
So the rear, basically the window, the rear window of the vehicle.
Well, I don't know what you mean by rear window. Are you talking a side window to the rear, or are you talking the rear window?
I was referring to the rear window.
All right, go ahead. As to your objection, G, well, the first one is to relevance. Maybe I'll overrule that objection as to hearsay regarding the defendant's statement. Isn't it hearsay?
Your Honor, I'm asking this officer to point out where in his written statement summarizing, he indicates that Mr. Folk changed his story about this back window panel.
All right, I'll allow it. Go ahead.
Sure. This portion here, if may I read it to you? I advised Falk his statement did not align with some information he had about his vehicle. It offered him the opportunity to clarify, which he replied, I couldn't tell you. I again offered Falk a chance to start over, as I did not feel his initial statement was entirely accurate. At that point, Falk stated he was taking his friend home after the Tigers game, spending time in Ann Arbor. After that point is when he describes the damage as occurring as part of this collision that occurred after losing control.
Okay, so to be clear, did he ever tell you that his car wasn't broken into in Detroit? Did he ever say, actually, that was a lie?
Did he verbatim state that?
Did he?
Not, no, he did not verbatim state, but this is the point in the interview, which he then clarified his initial statements and said that the damage actually occurred during this collision on the freeway.
Okay, but just to be clear, you never investigated. Actually, you did ask him where he parked at the game, right?
I did.
And you were trying to get some of that information, right? May I retrieve the police
You
report?
may.
Thank you. You did think that was relevant to your investigation, right? When you were asking questions about where he parked at the game, you actually thought that was relevant to your investigation, right?
Part of the way we interview people is to obtain their full statement initially, and then point out any discrepancies that may be there in obtaining the truth later on.
Okay. You started the interview by saying he wasn't in custody. Is that right?
Told him he was free to leave at any time.
Okay. You did not read him his Miranda rights, correct? You did not have him sign a waiver of his rights, right? You did not tell him he had the right to an attorney. And you physically drove him to the police station, correct? And he told you he thought he had to go with you, right?
Yeah, we had a conversation.
Okay. And there was you, and then there was another police officer who was in the interview room with Mr. Folk. Is that right? And both of you were wearing your uniforms, right? And you had your weapons on you, right? And you were sitting on either side of him, right?
Yes.
And he was not sitting immediately, he was sort of sitting in the corner of the room, right?
Yes.
He was not sitting right next to a door, right? And you told him that you've been doing this a while and you felt like he had a moral compass, right? And in fact, told him that it didn't seem like he should go to jail, right?
I don't know that I see.
You told him he didn't seem like a bad guy, right?
Yes.
And you don't remember saying doesn't seem like he'll go to jail. Okay. Okay. And he asked you if he needed a lawyer. You remember that? Sure.
I believe we were talking about going to jail that day after the interview.
I see. Okay. And in fact, you promised him that you wouldn't seek charges if he had hit an inanimate object. Isn't that right?
I believe I told him that I was not worried about leaving the scene of a property damage.
Okay. You promised him you wouldn't charge him with that, right?
Well, I'm good. What relevance would it have? The officer doesn't charge.
That's correct. But if the people are intending to use my client's statements as substantive evidence against him, his confession, which I believe they are, as that was the entire direct examination, then anything that has a bearing as to the credibility of his statements, including any promises that were made or implied by this officer in order to obtain those statements,
Would do what?
could impact the credibility of those statements and therefore the evidence.
It's sustained. Yeah, that doesn't make any sense.
Did you ever follow up with the witness he told you would verify what he was saying, Adrian Putnam?
No, I,
Okay. Do you know whose responsibility that would be, which officer?
normally it would be the officer in charge of the investigation. In this case, one of our detectives was assisting, so maybe him as well.
Okay. And do you recall discussing a pizza place or a pizza restaurant in Ann Arbor?
Yes.
Do you recall the name of which pizza restaurant he was allegedly at? Okay. So you didn't follow up on that aspect of the investigation. Is that right?
After the interview, correct.
And you were taking some notes on a notepad during this investigation, right? Did you save those notes?
If it's in my current notebook, it's in my back pocket. It's possible, if it's an old one, I should.
Okay. Is that a part of policy?
As to relevance again.
I'll overrule it. I'll allow a little leeway. Go ahead.
Is that a part of policy?
I don't know if our policy states or addresses that. I'll wait with you.
You're a sergeant, aren't you? And you were promoted just a couple months after this, right? Did you ever listen to any of the 911 calls on this evening?
No.
Did you ever obtain any police reports relating to this investigation? Were you aware of how many accidents there were on I-94 on this evening?
No.
Okay. Were you aware that there was another accident around the same time frame in that area on this night?
Again, no,
Okay, so you didn't hear those 911 calls.
no, I was not working.
Okay. And you never investigated the scene of this accident, right? you don't have any corroboration about what damage caused Mr. Folks was caused to his vehicle, right?
None other than his statement.
Okay. I have no further questions, Your Honor.
For point of clarification, the record is clear. There was an initial statement regarding damage to the vehicle that the defendant gave that it occurred in Detroit.
That's correct, Your Honor.
Subsequent to that, after additional questioning, he changed that to the damage having occurred on I-94.
That's correct.
Yeah. Okay, thank you. You may redirect.
Thank you. Ms. Young?
Yes. Okay.
When you interviewed the defendant, I believe you testified on cross-examination that at some point you made a statement that he thought he had to go with you. Do you remember that testimony? After the defendant made that statement, excuse me, what did you tell the defendant as it related to his requirement to being at the station?
I clarified that he was free to leave. That he was not in custody or under arrest. I don't know. That he was free to leave at any time, and he could end the conversation, the interview, and
Did you ever handcuff the defendant? You were also asked whether you had any sort of corroborating evidence that goes to the damage on defendant's vehicle. Do you remember that questioning? Showing defense counsel's Mark's People's proposed exhibit number 2. I apologize, I'm going a little bit out of order here. May I approach the witness?
Wait. Said exhibit J.
Have you recognized this document?
yeah, it's a state police laboratory report.
Can you take a look at that document for me, please? And specifically, what is that a lab report of?
Appears to be from this case, and it is testing some swabs that were taken from the vehicle. And that as well as
In your review of that report, is that report a fair and accurate representation of a report or the report that was received on this case?
yes.
And people would move to admit what's Mark's People's proposed exhibit number 2 into evidence.
Any objection or voir dire?
Yes, Your Honor, permission of voir dire.
Go ahead.
So, Sergeant, you have no certification in forensic science, right?
It's broad.
Elaborate, which means
Do you have any certification in forensic science?
Well, that's broad. So you're gonna, yes, it is. So you're gonna have to restructure that question because that is so wide open.
Okay, I was just
Direct question.
sure. Sergeant, you are not a forensic scientist, is that right? And you are not specifically trained in analyzing DNA, right?
in my rules for this department.
And you cannot testify to specifically what these results in this document means, right? Based on scientific knowledge, training.
I can't testify to the testing procedures.
Okay, to be clear, your name is not on this report, right? The person, forensic scientist, is Abby Newman, right?
Correct.
And in fact, this report was issued at the end of March, right? Of this year, March 2026.
The reports of February 11th, 2026.
Oh, do we have a different report? Your Honor, may I approach the witness to see?
You may.
Okay.
Can you look to the bottom of that page you're looking at? It says report issued March 26, 2026. Isn't that right? and I can point if that's easier.
Oh, I see.
Right. You see where I'm looking?
Yes, that's correct.
Okay.
And so your role in the investigation had actually concluded by March 26, 2026. Isn't that right?
Correct. My role in the investigation was inspection of the vehicle and interview of Mr. Moore.
Okay. And in fact, I don't know if you know the answer to this, but that was after the initial probable cause conferences in this case. Is that right? Okay. You don't know when the court dates were in this case because it's not your case, right? Okay. I have no further questions at this time, Your Honor. I would object as to, well, on a number of bases. First of all, I don't think this is the appropriate witness from which to seek to admit this report. His role in the investigation had concluded by then. His name is nowhere in here. He didn't testify as to any specific knowledge or experience or involved in this. So I would object on that basis. We didn't receive a specific notice that this would, be sought to use that exam. This is a situation where it was after the initial probable cause conference.
What is the requirement of the notice that it's going to be used? It was supplied to you.
It was supplied to us, Your Honor.
So what requires the prosecutor to give you notice that it may be used when it's supplied to you?
Well, Your Honor, I would argue, given the
Is there a specific statutory or court rule requirement that there would have to be the notice?
not that I'm aware of, Your Honor.
All right, go ahead.
The people did provide a witness list for the examination today. This is obviously a very, very complicated case and a very specific type of knowledge in order to make the conclusions that are made in this report about DNA analysis. It is possible that we would have sought to have the expert analyze this. However,
there has been a PCC in this case. This case has traveled through. This case was set for exam previously. It was adjourned at your request to today's date. And now you're telling me that you haven't done something and may not be ready. Is that what I'm hearing?
well, Your Honor, I would stand by my objection, Your Honor.
You're not going to answer my question.
Sure. So a couple weeks is not enough time to obtain an expert. It's not even enough time to, and so a couple weeks would not have been enough. This
Didn't just have it for 2 weeks though.
So this report was made March 26, 2026. My notes indicate the probable cause conference in this.
Are you asking them to bring in the author of the report?
Yes,
On what grounds?
to cross-examination in order to ask specifics as to how this was conducted, the testing procedures, the results in terms of 560 septillion times, 8.1 sextillion times, the differences between those two numbers. That would be.
The defense sought to obtain that test or that information from the author of the report.
Sorry, you mean, have I called?
You tried to get to the person that authored the report.
I have not called the author of the report, no.
Mr. Cook.
I don't know if the court needs a response, but I would say I believe this is admissible pursuant to MCL 766.11b, specifically section 1D, that allows at the preliminary examination documents such as laboratory reports to be admitted without the author being needed for preliminary examination.
Response.
Your Honor, I would stand by my objection. I don't think there's been foundation for this.
Objections overruled. Exhibit is admitted.
Thank you.
Any other additional questions of the sergeant?
I would just move to publish that exhibit to the court.
So. Either way, you just try to save steps. You need them. So, okay. Go ahead. Any other additional questions? Any additional questions from the defense?
No, Your Honor.
Sergeant, thank you very much. You may step down. The court is going to take a brief recess. What I'm going to suggest to council, my staff will be able to send you a copy if it went through. If the parties can stipulate on a map as to the exact location of the accident, would be appreciated by the court. If you can't reach a stipulation, then we'll get somebody in there to testify about it. But I'm gonna need a map.
Understood.
All right. Court stands in recess.
All rise.
In case of the people versus fault, are we ready to proceed, counsel?
Yes, Your Honor. I've spoken with defense counsel. We have a stipulated map that the people intend on introducing as People's Exhibit 3.
All right. Is that correct?
Yes, Your Honor.
All right.
May I approach?
Yes. Thank you.
And for the record, there's an X that is marked in blue ink on that map. That X was made with the troopers. The trooper marked that as where he responded and where he observed the decedent when he arrived on scene.
Got it. So. Okay. So I'm after the, I just want to make sure I'm heading east is to my right,
Correct.
west coming off of that curve. Okay. And so it's in that, it's actually in the stretch between the two curves to whatever extent, but by US 12. Understood. All right. Thank you. All right. Call your next witness.
People would call Trooper Douglas Ryan.
All right. Exhibit 3, if I didn't say so, is admitted.
Douglas Ryan, EOULASRYAN.
All right. Thank you. You may be seated. And you may inquire.
Thank you. Good morning, Trooper. How are you doing? Doing well, thank you for asking. Trooper, how are you employed?
State Sheriff, Michigan State Police.
How long have you worked for Michigan State Police?
6.5 years.
And has your duties been consistent over that 6.5 years?
Yes, I have.
Were you working on or about the early hours of May 25th of 2025? At any point did you go to eastbound I-94 reference a motor vehicle crash?
Yes, I did.
What time about was that?
About 2:28 morning.
When you arrived on scene, who all was there?
When I arrived on scene, there was a Huron Valley ambulance rig and 2 EMTs, as well as a Washington County Sheriff's Patrol car with 2 deputies.
What did you do when you arrived on scene?
When I arrived on scene, I parked my patrol car on the right shoulder behind the where the sheriff's patrol car and the ambulance were parked. And I got out of my car and saw a man that was lying in foliage on the right side of the freeway. There were 2 EMTs who were walking up to that man. So I walked up to assist as well.
How far, you said in the foliage, how far from the road was this man?
He was about 10 yards laterally off right side of the freeway. So the nearest paved part of the freeway is about 10 yards away from him.
Do you know how far it is from the last paved part of the freeway to the white fog line?
It's about 10 feet or so, almost the shoulder.
Okay. Was this man wearing anything when you found him? What did you do when you arrived with the 2 individuals?
So I saw that the man was limp. He had no front teeth. He had a gash on his forehead. He did not appear to be breathing or moving. So at that point, we decided that we had to administer first aid. So the paramedics or the EMTs brought a stretcher to the man, and I assisted in loading the man onto the stretcher so we could transport him to the ambulance on foot and then put him back in the ambulance.
Were you able to identify who this individual was?
Yes,
Who was it? And when I say this individual, I mean the man that you were transporting.
it was Sean Mullen,
How were you able to identify him?
his Secretary of State photo.
Do you know if an autopsy was ever done for Mr. Mullen?
Yes, there was.
Did you receive a report as to the findings of that autopsy?
I did.
Showing defense counsel to Mark Steeple's proposed exhibit 1. May I approach the witness?
Man,
Sir, I'm handing you a document that's Mark Steeple's proposed exhibit 1. Do you recognize that document?
I do.
What is it?
It's the Michigan Medicine autopsy report for Mr. Mullen.
And prior to today, had you seen this report? Is this a fair and accurate copy of the report that you received as it relates to the autopsy performed in this case?
Yes, it is.
Your Honor, people move to admit with Mark Steeple's proposed exhibit 1 into evidence.
No objection.
objection or voir dire.
No, you're-
Exhibit 1 is admitted.
Permission to publish to the court.
Yes. And it up to me. Thank you. Go ahead.
And so I realize I just took that document away from you. That document indicate the cause and manner of death.
Yes, sir. it did.
What was the cause and manner?
The cause of death was blunt force injuries and the manner of death was accident.
One moment, please, Your Honor.
Yes.
And I don't need you to testify anymore to that. So if the court wants to take the document back, I apologize.
It's making us work. Thank you, sir.
That's the witness.
Cross-examination.
Yes, Your Honor.
So, I want to start at the beginning. Oh, here's this. I want to start at the beginning of this evening. You were initially dispatched to this location due to the report of a naked pedestrian on the freeway, right? Incorrect. Okay. Why were you initially dispatched to this location?
But I was not initially dispatched, there were other troopers who were getting dispatched to this often assist.
Okay. What was the reason they were initially dispatched?
Was a naked man on the freeway who was holding down.
Okay. Sorry, so you said no to my question because you were not initially dispatched due to the report of a naked pedestrian. You were dispatched because there was an individual with an object in his hand. Is that right?
Okay. So there was another trooper.
Okay.
Two other troopers who were on patrol guard.
Okay.
Once a dispatch sent to the call, myself and Trooper Headley,
Uh-huh.
and we offered to assist them in looking for this man. So we dispatched did not send us to the call. We offered to volunteer to assist with the call.
Okay, Your Honor, permission to approach the trooper with his report?
Yes.
Trooper, I want you to look at the very first sentence of the report you wrote in this case. It actually says on the below listed date and time, Trooper Heatherly and I were dispatched to the below listed venue for a naked pedestrian on freeway. I read that correctly, didn't I?
Yes, ma'am.
Thank you. And you actually received multiple 911 calls about this pedestrian, isn't that right? And it was while you were en route to that location that you received an update that the pedestrian of interest was struck by a car, right? You did not. So at what point did you receive that update?
City. Talk to the paramedics.
Okay, so just to be clear, it's your testimony today that you did not receive that update while you were en route.
Correct.
Okay, may I approach, Your Honor?
Man. What's the relevance of this?
Your Honor, this is the credibility. He's the officer in charge of this investigation.
And what, so let's assume for the sake of argument that he received that information in route. Why is that relevant?
Your Honor, his answers to my question as to whether they,
Why is it relevant to me?
Your Honor, the the defense in this case and my argument as to bind over is going to be proximate cause. So it matters very much the timing of when the pedestrian was struck, as well as what was going on before the accident.
Before, so, but what, in answer to your question, what relevance is it going to be for me, even as to that issue?
So it makes a difference whether he was there when the accident happened or whether he.
Not claiming to be there at the time the accident happened.
So he's the officer who's in charge of this investigation, and he testified just now that he was not en route when he received any update. So I'm trying to figure out, again, just the timing of the series of events, what updates he received, what his investigation consisted of.
In what way does that relate to proximate cause?
First
So
of
where this trooper may have been. How does that, help me to understand how you even get there.
Okay, so first of all, it is foundational, right? His investigation, I would argue, is very important to this case. So I'm asking details about the information he had at the time and also the information he has now. His testimony.
So how does it relate to proximate cause?
It is foundational to the investigation.
Any response on it? Go ahead, but make it quick, because this is illogical to me.
So, Trooper, if you can read the second sentence of your report silently as I read aloud, it says, while we were en route, HPA advised that the pedestrian had been struck by a vehicle. I read that correctly, didn't I?
Yes, ma'am, it's correct.
Do you remember how many 911 calls there were about that pedestrian? Okay. Did you listen to all of them? Okay. Did you ever obtain any of them?
No.
Did you listen to any of them? Okay. As the officer in charge of this investigation, would that be a part of your responsibility or someone else's? Okay. And you didn't provide those to the prosecutor, right?
Correct.
So you don't know what time the first 911 call came about this pedestrian, right?
It's in.
Would it refresh your memory to review a copy of your report?
Yes.
Okay. May I approach, Your Honor?
So you can take a minute and look at your report. And
So the first call that was received at 1:03 a.m. by Van Buren Township PD.
Okay. 1:30 a.m. You said, I'm sorry, you said 1:03?
1:03 a.m.
Okay. Do you know what time the last 911 call was received?
2:28 a.m.
Okay. All right. And once you began investigating, may I approach to retrieve the police report?
Right.
Thank you. Once you began investigating, you realized that there were numerous police reports relating to the erratic behavior of the decedent immediately before the accident, right?
Police reports.
So you learned there was a police report from just hours before from Westland regarding suspicious circumstance of the decedent, right?
Later.
Okay. So later in your investigation, that's something you learned? Okay. Did you ever get a copy of that report? Okay. And so you never gave a copy to the prosecutor, right?
That's correct.
But you did talk to Sergeant Larson about this, right?
Yes.
And you learned again of the erratic behavior of the decedent from May 24th, 2025, right?
Check.
20. Respond.
This is foundational to his investigation.
No, it's not. It's still hearsay.
I'm asking him about,
Objection is sustained.
did you ever in your investigation come to learn of any details within the police reports concerning the decedent the day he passed? Okay, so you did learn of those details during your investigation, but that was not by reading the police reports. Is that right?
That is correct.
Okay, that was just by having a conversation with a couple other officers?
Yes.
Okay. And about a month before this incident, there were other police reports concerning mental health issues, right?
Objection.
Relevant.
Relevance as to, again, proximate cause, his behavior and his actions leading up to his death severs the criminal liability in this charge.
You got case law on that?
I do. It is, well, the jury instruction references the intervening superseding cause. People v. Schaefer.
Where would the intervening superseding cause be? I'm aware of that, but where would it be under these circumstances?
So if, and I'm happy to continue.
Answer my question.
Sure. So if there's an individual who was high on cocaine as well as other controlled substances, had mental health issues, running around the freeway at 3 a.m. naked, that would constitute an intervening superseding cause that severs the proximate cause, that severs the criminal liability. And again, that's People v. Schaefer, 473 Mich. 418, 2005.
So I'm going to let you go. That's not what that means, but go ahead.
Okay. So, Trooper, about a month before this happened, there was contact with the Warren Police Department regarding mental health issues.
What is the relevance of something a month before? How does that become a superseding or intervening cause?
Well, I have two.
Just proffer it to me. Ken.
Okay. The first is it relates to his lack of investigation, and the second is
Whose lack of investigation?
the police. If they're aware of potential police reports regarding an individual involved in a case from a month prior and they don't get those reports, that goes to the credibility of their investigation.
No, it doesn't.
Okay.
What's the other theory?
So the other theory would be if there was mental health, erratic behavior of someone who's naked on the highway at 3 a.m, that could explain why potentially they would be running around a highway naked at 3 a.m. And it could, that I would argue would constitute a legal division of criminal liability in this case, criminal responsibility.
I think your legal analysis is absolutely wrong in regard to superseding or intervening cause. I'm going to sustain the objection. I'm not going to allow testimony of this.
Okay. So I'm not sure whether I can ask the next question, but I'll ask it and wait for the court's ruling. Did you learn of whether the decedent had any ongoing legal issues relating to his mental health?
Going to object as to relevance again.
Sustained.
Okay. So to be clear, this is not a case where it was a head-on collision. Is that right?
Correct.
This was an allegation that the rear of the vehicle came into contact with something, right?
Not the rear of the vehicle.
Okay, which part of the vehicle do you allege came into contact with the decedent?
The right side toward it.
Right. Okay, so just to be clear, you're saying it was not the back of the car, it was the right side of the car. Okay. But again, that's not the front, right? There was no evidence whatsoever in your investigation revealing the front of this car came into contact with anything, right? You were in charge of investigating the area the decedent was located in, right?
Yes,
And you found a variety of auto parts, car parts in the foliage where he was located, right?
yes,
And in fact, one part had a VIN number stamped onto it, right? Okay. You don't remember if any of the vehicle parts found near the decedent had any VIN numbers on them? Okay. May I approach the witness, Your Honor?
You can take a minute. Would it refresh your memory to take a look at your police report?
it would.
Okay. Take a look at the police report.
And did that refresh your memory? So you did find a car part that had a VIN number stamped onto it, right? It's your testimony, you did not. May I approach the witness, Your Honor?
Did your partner find a car part that had a VIN number stamped onto it in the area?
No,
Okay, so just to be clear, that if I was to say a black auto part was found with a VIN number stamped onto it, you're saying that's not correct?
yes,
Okay.
You. May I approach the witness again?
Right.
Officer, what did you mean when you wrote this then?
By the way, he's a trooper, not necessarily an officer, so you'll address him correctly. Go ahead.
Just for clarification, so I can follow along, what page of the report are we on right
Oh, sure. It's page 2, the first paragraph, towards the end.
yes.
Well, can I just ask what part of your investigation was the basis of this section of your report?
So the number I believe you're referencing is not a thing.
What number is it?
The number right there,
Yes.
some identifying number, unique characters.
Do you know what number that is?
No,
Okay, did you ever ask anybody?
conducted research, internet,
Do you remember what your research showed?
that it belonged to a specific make and model of car.
Okay, and you found that it belonged to a specific Cadillac, right? From 2006 to 2009, right?
Yes.
To your knowledge, Mr. Folk has never driven a Cadillac, right?
Objection, speculation.
Sustained.
Okay. Was there ever any part of your investigation that connected Mr. Folk to a Cadillac? Okay. You also found other debris in the area, is that right? And in
We
fact,
go through every piece of debris that may be found on I-94.
no, Your Honor, I'll move on.
Thank you.
You also found that there was a ravine located near the decedent, is that right?
Yes,
Okay. And you'd agree that that created some uneven terrain, right?
yes,
And just a couple more questions about this issue. You didn't photograph all of the debris that you found on scene, right? And you didn't log them into evidence, right? Do you recall getting any calls about other accidents during the same time frame? Okay. In fact, there were a couple other accidents involving injuries, right? Okay, but you recall getting calls generally? And when you were driving on I-94, you saw there were other vehicles driving there as well, right?
yes.
Was it your responsibility to search the car associated with the decedent?
No,
Okay. Did any police officer ever search that car for evidence? Okay. Which officer do you think would, or is there any police officer that would know whether the decedent's car was ever investigated? You attempted to locate cameras that might have captured evidence regarding this incident, right? You were not able to find any license plate readers in Washtenaw County, is that right? And you didn't find any flock cameras in Washtenaw County, right? Did you seek to view any surveillance videos from any of the businesses nearby?
Right.
Okay. You did review the defendant's statements made to law enforcement, right?
yes,
You were aware that he indicated he was at certain businesses around the county, is that right?
yes,
Did you ever ask to view their surveillance videos? You are aware that many private businesses in Washtenaw County have surveillance cameras, right?
yes.
So I want to ask about the crash reconstruction investigation. You did have a crash reconstruction expert analyze this case, is that right?
Yes,
And you're aware, probably you were aware that the Bosch crash data was obtained, is that right?
yes,
And you reviewed their investigation, right? And they did ACM imaging, right? Okay. You're aware that no speed determination was able to be made, is that right?
I know.
Okay, you don't remember if there was any determination that was able to be made as to the speed of the vehicle? Okay. And I know that people admitted a map of the incident of the accident, but your investigation, the crash reconstruction expert indicated that there's no way to determine exactly where the decedent was struck. Is that right?
Same.
And just to be clear, do you remember the name of the crash reconstructionist? Okay, what was their name?
Yeah,
Okay. And did you oversee his investigation? Okay. Who did, if anybody? Okay. Would you say it's common in vehicular homicides to have no black box data indicating speed whatsoever?
I would say it's either common or uncommon.
How many vehicular homicides have you been the officer in charge on?
2,
Was this the first? Okay. Did you review the black box data in the prior one? So did you actually review the black box data for this case?
yes,
Okay. Were you able to make any sort of, did you learn anything from that?
I don't recall.
Okay. And I know you were here in the courtroom when Sergeant Bowden was testifying about his interview with Mr. Folk. Were you the officer, or I'm sorry, for that requested he interview him?
No,
Okay. To your knowledge, Mr. Folk continuously asked if it was him who did this, right?
I don't know.
Okay. Did you review his statements as a part of your investigation? Okay, but you don't remember whether that was a question he asked? Brief indulgence, Your Honor.
Yes.
So, the people's admitted this, exhibit in their, questioning of you, and you're aware that the autopsy revealed multiple controlled substances, within the, blood of the decedent. Is that right?
Yes,
You're aware that active cocaine was found in his system, right?
yes,
And you're aware that, the benzoylecgonine, which is the metabolites, 3,600 milligrams or nanograms per milliliter were found as well,
yes,
as well as another controlled substance, ecgonine methyl ester. Is that right?
yes.
You have no external or you have no external evidence about exactly what the decedent was doing in the moments leading up to the car accident, right?
Other than the statements from the witnesses, no.
Um, Your Honor, I have no other questions at this time.
May redirect.
No, Your Honor.
All right. Mr. Green, we step in.
Your Honor, the people have no further witnesses and would rest at this time.
Any witnesses for the defense?
No, Your Honor. Defense rests.
Your Honor, people have moved for bind over on the information specifically on counsel 1 and 2. Briefly, I think count 2 is going to be the less contested matter. I think certainly by a probable cause standard, people have shown the defendant was involved in a crash on I-94, that he failed to stop and render any assistance or to report that crash to law enforcement, and that he knew or should have known he was involved in a crash, and that crash resulted in the death of, well, Mr. Mullen. I know defense has said that they think this is a proximate cause issue, specifically as it relates, I believe, to count 1. I think count 1 is actually more of a mens rea issue as it goes to the degree of defendant's driving, whether it was reckless or careless. But I think there's 4 key factors that make this reckless and not simply careless. And those key factors are the defendant's admission to consuming alcohol, the defendant's admission as to the speed he was going, the amount of time it had been since the defendant last slept, and the possibility that the defendant was on his phone. As it relates to alcohol, the court heard testimony that the defendant admitted to having consumed alcohol earlier in that day. I believe he said a few, and then it was clarified to be 3 beers at a Tigers game. Certainly 3 beers is something that someone could handle with the defendant. I would again note is under the age of 21 and should not have been consuming any alcohol that day. As it relates to the defendant's speed, his testimony was that he was going 90 miles an hour. That's, as the court knows, well above the posted speed limit on the highway, about 20 miles per hour over. The ambulance, the HVA witness was able to hear screeching of the tires as the defendant tried to brake, but then apparently swerved off the lane of travel over the shoulder and onto the passenger side of the HVA vehicle, which was itself parked in the right-hand lane. So he went off the road as he swung out and lost control of his vehicle and hit the decedent here. The defendant also admitted being awake since 4 in the morning the previous day. This crash occurred at approximately 2 to 2:30. The following night, which by my math would be about 22 hours that the defendant had been awake. While the court did not hear testimony as to specifics of how lack of sleep can affect an individual's driving, I think the court knows and is plenty aware that sleep is incredibly important to being able to maintain concentration, be able to maintain a safe driving posture or mental posture. And the defendant nevertheless got behind the wheel and failed to do so, even though he knew that he was likely probably sleep deprived at that point. Finally, the court heard testimony that the defendant may have been on his cell phone. He did not admit to being on his cell phone. I'm a little concerned that he was unable to say he was not on his cell phone. And he said, well, he may have been on his cell phone. Certainly, that's not beyond a reasonable doubt, but I think it's a fact for the court to consider when it goes towards the overall mentality of this defendant. It's the people's position that he knew when getting behind the wheel, when he was operating the vehicle at 90 miles an hour at 2 in the morning on a dark road, that was wildly unsafe and with willful and wanton disregard for the safety of persons or property. I would ask this, and I would move this court to bind over on the information. Thank you.
Respond.
Yes, the people have not met even the low threshold to show that Mr. Folk was driving more than simply careless. The test, I want to make a correction that the people indicated defense testimony. There is no defendant's testimony. He is alleged to have made statements to officers that we are disputing the exact precise nature of those statements. They are contested. So understanding that the court is obligated to consider the evidence in the light most favorable to the people. But I just think that's an important correction, that these are not.
Where's that? I have to do what? You're saying I have to view this in the light most favorable to.
I sorry, maybe I was saying, I was trying to say, even if the court is viewing this in the light most favorable to the people, there's no sworn testimony. The prosecutor indicated defense testimony, and there's no testimony here. It's statements that he made to an officer. Of course, I'm disputing the credibility of those statements. That is the evidence that the people are relying on. There's no external objective indication of what the speed was, exactly what was happening. Speculation is not enough. Case law is very clear that speculation as to whether he may have been on his phone or he may have done that is not enough to withstand their burden. 3 beers at a Tigers game at 6 p.m. does not indicate what the people are assuming it.
Well, the court will take judicial notice that the Tiger game started at 7:15, so it's not 6 p.m. But go ahead.
Well, I had thought that he indicated he drank the beers before the game begun. But again, that is one of the issues in this case. They're using his interview as the basis of all of the evidence against him, is his interview with police, which obviously we have a lot of issues.
What do you mean by that?
His statements that he was driving and that he was consuming alcohol, and that he may or may not have been on his phone at the time. That these are pieces of evidence that the people just cited in their argument for bind over. And we contest that they are legally sufficient to bind this case over on the charge of reckless driving causing death. Your Honor, I believe this is a textbook case of intervening superseding cause. When you have an unexpected pedestrian who it's undisputed that pedestrian, the ambulance driver, who was the sole eyewitness that testified for the people, indicated he was acting erratically. She indicated that she locked the doors because he was, and I highlighted her statements today, but she indicated he was, scroll down to where I wrote down her statements, that he was, running up to their vehicle and he was on the shoulder running towards us, holding something in his hand. She locked the doors to the car.
I mean, that is significant that they didn't think this was a person who they were trying to reach out to give medical, that they actually locked the doors. And one of the other issues I want to highlight is she testified that she heard tires screeching before the thud, which indicates, it strongly suggests that the brakes were applied, and then there might have been a collision, which is the textbook, I think, break in the proximate cause analysis. And case law is clear. I mean, the jury instruction itself indicates that if there is intervening, superseding cause, proximate cause could be in dispute.
What
And that
you're arguing is the intervening cause.
the individual being on the side of the highway on cocaine, running towards cars on the highway at 3 a.m.
He's not in the roadway.
I'm sorry, on the shoulder of the highway.
And so that's the intervening cause.
Yes.
Okay.
And I think case law is pretty clear that the criminal standard for proximate cause is different, of course, and more than a factual cause and more than the direct causal connection than the tort concept of proximate cause. I know I don't have to go into this with the court, but it is proximate cause in the criminal context is specifically designed to prevent criminal liability from attaching when the result of the defendant's conduct is too unnatural or remote. That's exactly what we have here.
How is his conduct unnatural or remote?
Your Honor, my argument is to have a naked individual on cocaine on the shoulder, immediately within a couple feet of the shoulder, not near a car, there's no evidence that this behavior was natural or foreseeable or reasonable. The only evidence that the people have presented through their own eyewitness and through their officer in charge, who indicated that he received 5 911 calls about the erratic.
I know, okay, fine, but you're ignoring certain facts if you're making this an intervening cause type of case, aren't you?
Your Honor, that is one of my arguments against Feinberger, is that the people have to meet at every element, and there's no proximate cause here. They have not met that element. Even if they meet all of the other elements, even if this court is convinced that there is evidence of a factual cause, that there's evidence that Mr. Folk was driving the vehicle in question, which of course, we would argue against, but even everything else, I don't believe that there is any evidence of proximate cause. And so I don't believe the court can bind this case.
When you're saying that there isn't any evidence of proximate cause,
there's not enough evidence, excuse me, legally sufficient.
what do I do with the lights on the ambulance? With your argument?
Frankly, Your Honor, it helps my argument because it provides the reason for a break. And so that is
A break in what?
the vehicle braking, which is what led to the accident.
So the very fact that a driver must have their vehicle under control, I'm just trying to follow your argument, at all times, and that there is an ambulance or emergency vehicle with their lights on, is the intervening action that led to this?
No, Your Honor, the pedestrians, that's the intervening. The ambulance lights that's not, just to clarify. The ambulance lights could, I think it supports my argument in that lights on a curve, and the court has the map. I actually printed out for the exam, but the court has the map. This is on a curve. So ambulance lights on a curve, a car braking, and having an individual within feet of the line on the side of the highway, not farther back. I mean, the ambulance driver herself said he was within a couple feet of the white line. He was right there. And so that is unnatural. It's not foreseeable. And that is the intervening superseding cause.
Why would it not be foreseeable if I see lights on the road from an emergency vehicle, that there would also be people?
It's foreseeable that there would be people in a manner consistent with rendering aid, but
I buy your argument. Well, right, but if I buy your argument, which really isn't making much sense to me, but if I buy your argument, that means every time an emergency responder stops on the side of the road, activates their lights, a driver potentially could hit, say, a police officer or first responder of any type, but it's not foreseeable. You're arguing that it's not foreseeable that there would be a person out there.
can I clarify? My argument is the behavior, and this is exactly why I was trying to get into the details of the erratic behavior. Police officers, ambulance, they behave rationally. They are lifesavers. They don't run across.
Walk on the side of the road all the time and respond.
Your Honor, the issue here is we don't have any.
You've argued foreseeability. I'm trying to grasp that notion of foreseeability. If I'm driving down the road and I see emergency lights from an emergency vehicle, it is foreseeable that there will be people.
People, sure, but not necessarily people who are on cocaine behaving erratically. I mean,
I don't know what they're doing. But it isn't. You're saying it's not foreseeable that there would be a person there. That's really what you're arguing, regardless of what their behavior may be, because they're still off the roadway.
Your Honor, to the extent that was not my intention to be my argument. My argument is in this specific case, given that there is evidence, there's undisputed evidence that the individual was acting erratically on cocaine.
Counsel, how do you make the specific argument that it's not foreseeable, but only limited to the facts of a particular case? Because that is counter to the notion of foreseeability.
Your Honor, the issue here is we don't know what the actions were. If it was a police officer or if it was someone who was there, they would be able to say, this is what the person was doing. We don't have that here. And I was trying to get into some of the 911 calls.
Yes, we do. We have the testimony of the view of the emergency responder.
So obviously the court is, is more aware than I of what she said, but she did testify that she said, he's charging at us. He could be a danger to himself, others. He was running with something in his hand.
But then he's running away at some point.
Right.
And then the vehicle hits it.
Right. And she, Your Honor, my argument is it's the people's responsibility to put forth the specifics of if they're accusing and they're choosing to charge Mr. Folk with this, what was happening that led to this accident. And my argument is the specifics that she testified to, in fact, raise more questions than it provides answers as to how this person.
You're all over the place. Because if you're arguing proximate cause and foreseeability, then I'm not following that. Because part of that argument is if I see emergency responder lights and I'm driving a vehicle on a roadway, is it foreseeable that there may be people? You're obviously arguing that it's not.
It matters what the people are doing. It matters their actions and where they are and what they're doing.
You know what? It's obviously you have an argument to make. I'm going to take a brief recess. I'm going to let you get your argument together and then come and give it to me in some cogent way that maybe I can understand what the heck you're talking about. Because right now I don't understand what you're saying. Court's in recess.
All right.
Think that he could be a danger to himself or others. So this is different from any situation in which any medical or police or any other person is just merely on the shoulder of the highway or standing on the shoulder of the highway. In those cases, the actions of those individuals likely, we wouldn't have testimony that someone was running towards incoming vehicles. And I just also want to highlight that she and the officer specifically referenced safety protocols and procedures in place to entail safety when there is an ambulance on the side of the highway. So we heard specifically testimony which involves preventing cars from traveling in the lanes nearby, restricting travel on the highway for this reason. So that would be my argument, Your Honor.
Anything additional?
Briefly, Your Honor, touching on 2 points defense counsel made. Defense counsel rested in part her argument that the decedent was acting erratically. I believe the language was charging at the ambulance. My recollection of the testimony from Miss Grady was that the defendant was off the lane of travel on the shoulder at the time that this crash occurred. So to any extent that he was acting erratically in the place where the defendant shouldn't have been driving regardless of what he was doing, because the defendant should be maintaining the lane of travel, not driving into the shoulder. Defense counsel also, I believe, made an argument before we took the recess that there's no evidence other than the defendant's statement to Sergeant Bowden about how fast the vehicle was going. And while certainly there was no mathematical calculation put before the court, I believe the testimony was that the decedent was found, I believe it was about 10 yards off the road, which then had several more feet from the fog line to the end of the pavement. And that itself was, I believe, the Miss Grady testified about 150 yards down the road. To move that far from the early indicates that it does not give an exact number, but it corroborates the defendant's own admission to Sergeant Bowden that he was going 90 miles an hour approximately. For those reasons, for the reasons I originally stated in my motion for bind over, I would again move this court bind the defendant over on the information.
Sorry. Okay. All right. Let me just say at the beginning that I think that maybe the decedent's family back there, and I've been watching the defendant ever since sitting on the bench. The cases that the defense of what might be negligent homicide, but they are always difficult because a lot of times in cases you have good people, you have bad people. But in these cases, you can have good people all around, and a bad thing has happened, and it's not. It just is what it is. With reference to the arguments in this case, let me just say, I think, given the testimony in this case with reference to count 2, the failure to stop at an accident scene where there was a death involved, that being count 2, that the people have indeed sustained their burden on count 2. The testimony of the HVA responders, Miss Grady, particularly as to the vehicle going past the ambulance. At that point, then staying there approximately 30 seconds and then taking off, I think substantiates that charge. With regard to the charge of reckless driving causing death, I think certainly that there are factual issues involved as to what the defendant's vehicle was doing. At the time, I think the location is important. I think that the people, as it relates to that charge, have also sustained their burden. The court, and I want to make it very clear, the notion of superseding or intervening cause and the foreseeability of whether or not this individual would be here is not limited to this individual being there. Did he come across a circumstance which should have been foreseeable for a driver on a highway? Take all of that as to a determination of foreseeability and causation. One has to remember that the ambulance is there. I had specifically asked Ms. Grady whether the lights were fully activated. The lights are fully activated. That is consistent with the statement that the defendant gave Trooper.
After hours of testimony, arguments, and challenges from both sides, everything comes down to this critical ruling. The judge carefully pieces together the evidence, focusing on the defendant's speed, the visible emergency lights, and the circumstances leading up to the collision. This is the moment where legal theory meets real-world consequences, as the court explains why enough evidence exists to move the case forward. It is a powerful conclusion that signals the case is far from over and that much bigger questions still await resolution.
For whatever reason, he assessed the lights, at least according to what he told the trooper, as being on the other side of the road. And then the accident happens. I'm here to make a probable cause determination as to whether or not the defendant, there's probable cause to believe that he was driving recklessly, and that in driving recklessly, that caused a death. The concept of a reckless driving is driving with a willful or wanton disregard for the safety of persons and property. I think that when you have an emergency vehicle, you're traveling, by the defendant's admission, he was doing 90, which would be 20 miles per hour over. It's even more so in terms of an excessive speed where there is an emergency responder's vehicle, because one is required to slow to a point that didn't happen. I think there is certainly enough to believe that the defendant was driving recklessly, particularly since his vehicle struck the decedent and then had enough force and momentum that he could not control that vehicle, and it continued past the ambulance that was there to ultimately try to deal with the individual on the side of the road. Maybe the argument of proximate cause, there might be a factual development that would lead that to be maybe addressed in circuit court. But from a factual standpoint, the court, in looking at all of this, believes also that will have sustained their burden and would also bind the defendant over to stand trial on the count of reckless driving causing death, or taking all of the factual circumstances into account during the course of the testimony.
We would wait for a reading, stand mute.
And then, having waived formal reading, standing mute, the court will enter a not guilty plea as to both counts. Pre-trial in this matter will be set
August 11th at 1:30 with Judge Cook.
August 11th, 2026, 1:30. Anything, Esteban?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
We'll continue.
When appropriate, may I approach to sign the information?
Yes, sir. Mr. Bellinger, can I see you in back, please?
Yes, Your Honor.